Am I audible? Can we start? Can we start?
Hello.
Can we start, sir?
Am I audible? Am I audible? Bhattji, good evening.
Good evening, sir.
Hello.
Panigiri sir, I'm starting the meeting with my introduction. Can
Okay,
we
sir.
start?
Yes, sir.
Yeah,
Start.
Okay. Yeah, start. Good evening and warm welcome to the bankers, insolvency professionals, members of our company, Persistent Insolvency Professionals Private Limited. Today, that is 3rd December 2022 at 6 p.m. I am Rajendra Purani, Director of Persistent Insolvency Professionals Private Limited. Our company is made up of 126 insolvency professionals and values all over India. Our company was incorporated on 14th February 2022 with head office at Hyderabad and corporate office in Mumbai. Other directors and promoters on the board are Mr. KJ Vinod, is the chief promoter, Mr. Anup Prakash Avasti, Mr. Narsimha Prasad, Dr. Nand Kishore Singh, Mr. Paramjit Singh Sethi, Mr. Pradeep Kumar Kaushik, and Mr. Vimal Kumar. We have 127 offices pan India with presence in all 15 NCLTs from Allahabad to Kochi and from Rajasthan to Kolkata. Our team is made up of CAs, ICWAs, accountants, then company secretaries, bankers, advocates, and evaluators in all three categories: plant and machinery, land and building, and security and financial assets. Across India, we handle almost more than 140 plus cases through our IBC professionals. We have advisory board of eminent person who has experience in handling and monitoring 2,000 IBC cases of biggest nationalized bank, MDs of companies, ex-chairman of the bank, and Supreme Court advocate. Our website is www.persistentinsolvencyprofessionals.com. You can give any suggestions to our info@pipeople.in. Sir, we are having a seminar twice, right from 14th February 2022, because our company was formed on February 2022. So almost 15 seminars were conducted twice in a month. So this is almost 16 seminar we are having with you. So actually what we are having, sir, today we are having Express IP Sri JIGAR BHATT sir to deliver his lecture on resolution of IBC 2016. So basically our base purpose is to know exact practical lesson from you, because everybody is here IPR, everybody is having theoretic knowledge, but through your lecture we want to know exact practical aspects of the IBC cases. So with this I welcome you, sir, to our PIPPL platform. I'll then request Paramjit Sethi to take over the proceeding. Thank you.
Thank you, Puranik ji. Our today's speaker is one of our member. His name is Jigar Bhatt. He is a rank was 24. He is having a more than 15 years of experience in BFSI sector. He has his own firm, and he has a specialization in stressed assets resolution, due diligence, legal advisory, valuation, and transaction services. He is also a forensic auditor. He is experienced in bankers, lawyers, company secretary, and chartered accountancy. Specialized in advisory, legal services, and rehabilitation of business. And besides this, his area of expertise includes corporate and appearance before authorities, transaction audit, credit risk assessment, product process policy development, etc. He has handled 5 CRP cases as a resolution professional and 1 case as a liquidator. He has also provided CIR process advisory services for 10 IBC cases. He is transaction auditor in more than 5 forensic audits. So with these words, I present before you our great speaker and our member, Mr. Jigar. Welcome, sir.
Thank you so much. Thank you so much. Thank you for such a warm introduction. But so At the outset, I would say I am not an academician and I am not a lawyer. So basically, I am an insolvency professional and a chartered accountant, and I would like to be called an entrepreneur, because as an insolvency professional, you have to be an entrepreneur because you have to understand the corporate data from various angles. So from a RP side, from COC side, from NCLT side, from resolution applicant side. So thank you so much, Sethi ji, for such a long introduction. So can I share my presentation? So it would be a better to connect the audience, and then we can have a structured flow of the
Yeah, let me give you the sharing right.
Yeah, please, sir. I think I do have sharing rights.
Anyway, continue. Now you have. Continue, Bhattji, continue.
Yes. I am just. So I believe the screen is visible to all the participants.
Yes, clearly visible.
Thank you, sir.
Welcome.
Thank you so much, sir. So as Sethi said, today's topic is resolution under Insolvency and Bankruptcy Code 2016. So at the outset, I would like to thank the Persistent Insolvency Resolution Private Limited for giving me this opportunity, wherein I can share whatever knowledge I have gathered in last 3 to 4 years since inception of IBC, and from the day I started practice in Insolvency and Bankruptcy Code. So this is a corporate debtor basically, and it's a car which has been damaged. It had a severe accident, and now it can't function. It's a corporate debtor, and this is the job. It's a committee of creditors. This is a corporate debtor, and this guy is an insolvency professional. And since today's topic is about resolution, as a resolution applicant, we have to show it to all the stakeholders. We have to convince a resolution professional. We have to convince a committee of creditors, and then the most difficult part, we have to convince adjudicating authorities that yes, we are the people who are capable to turn this ill car into a brand new car which will run on the road at the fastest speed. So this is a resolution.
Excellent, sir.
Yeah. So this is a task. So it's a 3-slide car which has met an accident. We have to take it to the repair service station. We have to cure it, and then we have to make it a brand new car. So in today's meeting, I have kept 6 agenda items to be discussed upon. So see why? Because after conducting so many committee meetings, I feel that agenda items should be there so that there would be a proper meeting which will have some purpose, and at the end of the meeting we'll achieve something out of it. So resolution proposition from the perspective of, as we know, it's an insolvency bankruptcy code, but the word resolution appears in several ways. We are interim resolution professional. We are resolution professional. There is a corporate insolvency resolution process. There is a resolution applicant, right? So why? Because ultimately the purpose of the code is to resolve a corporate debtor and to unlock a capital which can be used toward more productive purposes. So as a resolution professional or say resolution applicant, ultimately our goal is to resolve the company. So whenever there is a resolution plan, it will have a different perspective. A perspective of a resolution professional would be different. Perspective of committee of creditor would be different. Perspective of adjudicating authority would be different. Perspective of other stakeholders, that is operational creditors, government department, employees, that would be different. Perspective of resolution applicant would be different. His aim is to acquire the corporate debtor. There is another side of it. Perspective of unsuccessful resolution applicant would be different, because if out of the 3, one is becoming a successful, then other 2 will definitely going to contest that even we were eligible and our plan was better than the person whose plan has been selected. So we have to contest with those people as well. And lastly, so perspective of suspended management would be different, because whenever you present a resolution plan in the committee of creditors meeting, suspended management would be there. Unless it is under section 240A, wherein suspended management themselves offer a resolution plan, that would be a different story. However, if it is a third party plan, then it is very difficult to deal with the suspended management, because they are going to find a lot of flaws, and they'll say that this plan is not a efficient plan, and it is not a feasible and viable. So we have to deal with around 6 to 7 different perspectives. Now, if you are a resolution professional of a corporate debtor, then it is your duty to manage all these stakeholders, and you have to show it to the committee of creditor and then subsequently to the adjudicating authority that this is the plan and which is having capability and feasibility and viability for revival of the corporate debtor. So if I say resolution professional is interested in getting the plan approved, right? And after introduction of this success-based fees, now we have actually a task, because earlier, if you resolve the corporate debtor, okay, people will say, okay, fine, great, you have done a great job. But if you bring corporate debtor into liquidation, then you will have a fees based on the realization and distribution. But for successful resolution, there were no fees. But now, after certain amendments which have come into picture from October 22, now we have 2 sets of fees. So one, if you resolve the corporate debtor within 270 days, so certain slabs are available. If you resolve within 180 days, within 270 days, like that. And if you are able to recover and realize out of the successful resolution plan anything above fair value, then there would be another set of a success-based fees. So ultimately, as a resolution professional, our target is to resolve the corporate debtor, and that too with a value maximization. From the angle of committee of creditors, all right, so they have got all responsibility with respect to commercial wisdom. So it is up to the committee of creditor to evaluate the plan and to decide whether this plan is feasible and viable or not. As a resolution professional, it is our duty to table only those plans which are IBC compliant, which includes feasibility, viability, and capability of the resolution applicant. Committee will have a look at other waivers as well, because sometimes in resolution plan, people ask for so many waiver, which even committee of creditor is not having authority to deal with. And as you all are insolvency professional, most of are practicing into IBC field, always committee is adamant with respect to waiver of corporate guarantee. And usually, even as an independent resolution applicant, I would be indifferent whether to go for a waiver of personal guarantee or not. But technically, if I want to run a complex business, then I would require support of the ex-management, because they were the people who had a deep knowledge and detailed knowledge about the corporate debtor. Especially certain specialized business is required a support from the suspended management, because certain clients are like that. Without the cooperation from the suspended management, you won't be able to restart the business. So waiver of corporate, this personal guarantee, usually committee don't offer. But to get the waiver, actually, we have to offer a differentiated plan. We have to say that I am bidding for the company for ₹100. However, for the waiver of the personal guarantee, I am ready to give another 25 rupees. If we are able to demonstrate that certain amount is for the corporate debtor and additional amount is for the personal guarantor, then for the committee of creditor, it would be easy to make a commercial call. If you clear the hurdle of the committee of creditors, then comes the adjudicating authorities. So now adjudicating authorities is having a jurisdiction to evaluate the plan from certain provisional angles. However, nowadays authorities go much into detail, and we have to show them that the people who are declared as a successful resolution applicant are having capability to implement the resolution plan, because their concern is also valid. They say, after investing so much of time, if resolution applicant fails to implement the plan, then company will go into liquidation, and there will be another course of a legal action, and it will burden the court. So in my experience, I have seen approval of the resolution plan in Ahmedabad NCLT, Mumbai NCLT, and Delhi NCLT. So they go much into detail. So if you are engaging services of a council, then you have to be with council, because council will have a basic understanding about the resolution plan, and he is expert in the court processes. But whenever there are some technical questions or a detailed discussion happens, then your presence would actually save 2 to 3 adjournments. Then comes the other stakeholders. So as I said, the agony of the law is that lots of applications are triggered under section 9. However, whenever there is a resolution plan, operational creditors are not getting anything. So I have seen nowadays even operational creditors are opposing the resolution plan in the court of law. Then there would be a government department. So before this rainbow paper judgment, it was a very settled law that we were not paying, or we are not supposed to treat governments separately. They were part of the operational creditors itself. But now after that rainbow, I hope everyone is aware about the rainbow paper, because it was very famous judgment, and it has actually challenged the entire premise of the insolvency bankruptcy code. So till the time that issues get settled, we have to treat government dues, especially state tax department of government of Gujarat, at par with the secured financial creditors. Then you have to deal with the unsuccessful resolution applicants and then suspended management. So now I'll move on to the basis and premise of the resolution plan. So if I am interested in acquiring a corporate debtor, or I may be a consultant to a company which is interested in acquiring a corporate debtor through merger and acquisition, right? So here I have jotted certain bases and premises on which a resolution plan should be structured. So first of all, invitation of expression of interest, that is Form G, that is the starting point. So as you know, people do publish the same in the newspaper where corporate debtor is having registered office, and even that is available on the website of the IBPI as well as of the IPA. So if you are interested in the company, then you have to see what are the dates of the Form G. If you or your client is interested in bidding for a certain corporate debtor, then you have to request for the expression of interest process document, which is having an eligibility criteria. So before publishing Form G, usually resolution professional, not usually, he's supposed to decide the eligibility criteria. He is supposed to get it approved from the committee of creditors. So mostly in eligibility criteria, you have to see 2 criteria. One is a net worth statement, because if corporate debtor is of X size, then anyone with lesser than X net worth won't be eligible to bid for that corporate debtor. So that is one. And another is a experience in similar line of business. So if you are acquiring an entity which is in similar line of business, then that is fine. But if you are in separate line of business and you want to acquire a corporate debtor which is in a different line of business, then always try to have a consortium. Try to have a consortium member who is having certain exposure into the similar line of business, because it will add to the value proposition to the committee of creditor. If you pass that stage of submitting your expression of interest and you become eligible and you are declared as a prospective resolution applicant, there would be a provisional list, and then subsequently it would be a final list. So if you are into provisional list, then the resolution profession would share us the information memorandum. So now this is the document, because the resolution plan has to be structured considering information memorandum as a center idea, because information memorandum is having the entire history of the corporate debtor, present status of the corporate debtor, what kind of asset the corporate debtor is having, and what are all legal cases which are pending against a corporate debtor, and lot other things. So once you are into that stage and you are into the prospective list of the prospective provisional list of the prospective resolution applicant, then you will have an access to the information memorandum. It has to be studied in detail. So line by line, page by page, it has to be studied in detail. Subsequently, you will have a request for resolution plan document, that is the RFRP. So now in RFRP, the RP and the committee of creditor decides that resolution plan should be in a specific form. See, as such, there is no standard format for resolution plan. However, RFRP would define what would be the process for submission of resolution plan, which should be the minimum content that should be there as a part of the resolution plan, what kind of annexure you need to produce. For example, I am a partnership firm and bidding for a corporate debtor, then they would have defined that I need to attach my partnership deed, it should be registered deed, then I would require 3 years of financial statement, my bank statement, my net worth statement, authority letter, power of attorney. So RFRP document, so along with information memorandum, RFRP has to be studied in detail, because nowadays, because this law is evolving, now even committee of creditors with whom we are going to deal as a resolution applicant, they must have managed n number of cases. So over the period of time, they also know that what should be the criteria and how to fix the things so that there should not be any subjectivity later on. Say for example, with respect to avoidance transactions. So earlier avoidance transaction used to be left with the resolution applicant to decide upon, but nowadays committee of creditors categorically provided that any application pending with respect to avoidance transaction has to be dealt with even after the approval of the plan, and if any amount gets into the corporate debtor, then it would be the property of the stakeholders and not of the resolution applicant. This is just an example. So if you are a consultant or if you are a company which is trying to acquire a company into CIRP, then you have to study the RFRP document in detail, and your plan should cover all clauses which were provided for in RFRP document. Then evaluation metrics. So evaluation metrics is basically a scoring criteria which RP and COC decide. So if there are more than one resolution plan, then the comparison of the plan would be based on the evaluation metrics. So whenever you are providing or you are giving a consultancy to any resolution applicant, or you are bidding for a company, you have to study evaluation metrics in detail, because plan a financial proposition which scores maximum marks. So if there is a criteria wherein you say you are providing an NPV and it is having certain range, so for 10 to 20% of realization, if you are getting 5 marks, and in 21 to 30% you are getting 7.5 marks, so always try to bid for 21%, don't bid for 20%. There would be an incremental outflow, however your scoring would be on a higher side. So always structure your financial deal based on the evaluation metrics. Valuation of the corporate debtor. Now under CIRP, obviously RP is going to do the valuation of the corporate debtor, but as a resolution applicant, you also engage a services of a registered valuer or any expert into the valuation field, because it might cost you some rupees. However, it will give you an accurate idea about the value proposition that corporate debtor is having. And any which ways, as a resolution applicant, we as a PRA, I would say, we do have a right to have our own due diligence. So request a visit to the premise of the corporate debtor, engage service of a valuer, and so then you will be able to bid quite accurately. See, as a resolution applicant, I want to get company at the lowest price. So I want the company at the liquidation value. So to check what could be the liquidation value, always engage services of the registered valuer. Then before preparing a resolution plan, or before you start preparing a resolution plan, get the corporate debtors ROC data. Download entire stuff from, don't rely on the data room shared by the resolution professional. You should have your own due diligence. So nowadays there are a lot of AIs are available which give you a detailed data. You don't have to punch in that CAPTCHA and download single document. You do have a AI which downloads the entire stuff for you at a single go. Have a proper analysis about the corporate data through ROC filings and all. Then try to conduct a legal due diligence of the corporate data, including avoidance transactions. So as I said, there are a lot of AIs are now available which give you a legal due diligence of the corporate data as well. In information memorandum, usually RP provides for all the litigations which are pending before various courts. And but the issue is that now RP is getting a larger time, but till October RP was getting only 54 days. So now within 54 days, you need to verify so many claims, and so you are left with hardly 10 to 12 days to prepare an information memorandum. And as a professional, we know once we prepare the document, though it's a dynamic document, but usually people don't upgrade the document. Once it is prepared, it becomes a legacy document. So it is always better that as a resolution applicant, we should do our own due diligence on the corporate debtor, because in a resolution plan, you have a liberty to ask for the waivers for whatever legal matters which are running. But if you say you are putting a statement of general waiver, then it would be very difficult at subsequent stage, if your plan gets approved, then to get it implemented with various authority. If you don't have that specific legal matter waiver, then it would be a task to convince them. So always try to have a legal due diligence of corporate debtor, have all details about whatever case which are running, take a clarity from the resolution professional, and consider all those legal matters in your resolution plan. Yeah, this is very important. Profile of a resolution applicant and connected parties. So these all details were related to the corporate debtor. Now you have to demonstrate that you are the best amongst all to bid for this company, and for clearing that feasibility, viability, and capability yardsticks, you have to show your profile quite accurately, present it well, give a proper history of your evolution. Also mention whosoever is your connected parties, because ultimately after submission of the resolution plan, RP is going to do a 29A due diligence and vetting of resolution plan. So why to give that opportunity to RP? You only do your due diligence and you produce it in your report that these are the connected parties, and produce that you don't have any connection with the corporate debtor. So the better you present in your resolution plan, there would be a lesser due diligence from the RP's angle. So in your profile, show your history, how you have grown. If you have done any acquisition in the past, then it gives a lot of advantage at the NCLT stage. Produce a proper revival strategy, both subjective as well as objective assessment. So in your resolution plan, provide that how you are going to revive this corporate debtor. So how you are going to address the cause of default. In subjective, always you can refer to the industry and why that corporate debtor has failed, and what circumstances currently available in which you would be able to revive that corporate debtor. Because even suspended management was expert. They might have run company for a decade or 2 decades or maybe larger than that. But if they have failed, then some issue was there. So you have to address this issue and you have to demonstrate why you are the person who is under current circumstances going to revive the corporate debtor. So have a proper story, proper narrative with a proper facts, data, and produce that feasibility, viability is proven and you are addressing the cause of default. In objective assessment, always try to give figures, provide a proper projections, factor the source of fund which you are going to bring into, what would be the cost of fund, have a proper projection of the financial statement, so that and don't see in whenever we make any proposal seeking loan from any financial institution, we do prepare a CMA data, but that CMA data is a different, and here objective assessment is a different. So try to put in perspective and have a proper projection which shows that what would be the growth for first year, what would be the growth for next 2 years, and after 3 to 5 years and 5 to 10 years. And especially if your resolution plan is having a term of kind of 1 year, 3 year, 5 year, then till the plan term, always have a very accurate analysis of the projections. Also use judicial pronouncements. So if you are really interested in this profession, then always try to track the orders which are pronounced for approval of the resolution plan or rejection of the resolution plan, because in those orders, authorities make specific observations. So if we are aware what kind of observations are made by the adjudicating authorities, then we can address those problems into our resolution plans. So always have a track over the cases. And especially if you are working in a specific region, then always try to attend that court at least twice a week. So you will have a I hope everyone is with me. Participants,
Yes,
are you
yes.
with me?
Yeah.
Yes.
Please.
Very well. Please go ahead, sir. Please go ahead. We are with you.
It seems like I am just talking to myself.
Yes.
Okay. Anyway, so if you are working in a specific region, then always try to attend that NCLT at least twice a week, so that you will have an idea what kind of questions they are making. Because ultimately, if you are going to be a resolution professional or even a resolution applicant, if you know what kind of observations they are making, because there would be a certain pattern, everyone is having a certain pattern. So try to get that pattern, try to address those issues in your resolution plan. All right. So anything to discuss on these points? So to me, this is the basis and premise for preparing any resolution plan. Shall I move ahead? All right. Now we'll quickly move to this mandatory provisions of the code, because I don't want to be sound repetitive and just reading the provisions of the code, because I'm sure you all know the provisions of the code might be better than me. So I'll just brush it up. So mandatory provision of the code, you have to deal with section 30, that is submission of resolution plan, regulation 36B4, which says providing of performance security, section 25(2)H, invitation to eligible PRS. You have to show that you are an eligible one, matching with all the criteria. Regulation 37, that is resolution plan, or so regulation 37 is very important because it gives you as a resolution applicant lot of power, lot of liberty to address issues and to restructure the corporate data. So regulation 37 is having around 10 to 12 clauses which allows you a liberty to restructure the corporate data. Then regulation 38, mandatory content of the resolution plan. Regulation 39, approval of the resolution plan. So now approval of the resolution plan, as a resolution applicant, it is beyond my control. But if I am giving a resolution plan, I should see while approving what kind of due diligence or what kind of verification they are going to do. If I'm aware that they are going to do this verification, then I should provide for all those clauses very easily in a simplistic way, and I should address everything so that my plan will get through easily. Then the most important, section 53, distribution of asset. I have seen people are missing on this part, and they are, in my recent matter, it is pending. So I won't be able to give the name of the matter, but a plan has been rejected because he has breached this waterfall for 1.29 lakh rupees. He had provided 1.29 lakh rupees additional payment to a class which was otherwise not eligible to get the distribution under section 53. So only based on that parameter, his plan was rejected by the committee of creditors. So these are the provisions and sections that you should know in detail, and you should address in your resolution plan clause by clause. So give a referencing in your plan where you have complied with the provisions, all these provisions. See, all these sections are having very detailing about what should be the part of the plan and what should not be. So I have just accumulated all those sections, but I'm not going to read these sections. This is section 30, quite long section, and adjudication authority focuses on section 30 subsection 2, and even resolution plan is supposed to put up only those plans which are compliant under section 30 subsection 2 to the committee of creditors. So this is the heart of the compliance. Then, as I said, regulation 37 is having a lot of options to restructure the corporate debtor. So it's like transfer the asset, sale of part of the asset, substantial acquisition, satisfaction or modification of security interest, curing or waiving of any breach, extension of maturity date. And so it is A, B, C, D, F, G, H, I, J, K, L, up to L options are available. So you have to exercise, you have to see, so what are the expectation of the the person who is trying to acquire the company, and advise accordingly. And wherever the waivers are required, always be specific. You should demonstrate that you are asking for certain waiver under which clause. So it makes easy to sail through the plan before adjudicating authorities. Then there is a regulation 38. it talks about payment to operational creditor and etc. But how, if you see sub regulation 3, there are only 5 points, but very critical points. The plan should address the cause of default. Now it is a 5-word sentence, address the cause of default. But as a consultant, as a person who is advising a resolution applicant, you have to go into detail and you have to provide a proper analysis that how you are addressing the cause of default. Second, feasible and viable. Now these 2 words, feasible and viable, are subjective. So whenever there is objectivity, you will be able to deal with, okay, my numbers are speaking, so that there is no much to talk about, and even my numbers can speak. But when there is a subjectivity, you have to demonstrate. Now feasible and viable, that committee is to decide. So you have to show why your plan is feasible and how your plan is viable. So for example, if you are saying that you are bidding for this company for ₹100, then demonstrate that you do have a sufficient liquid assets available to fund this proposed plan. That is a kind of a feasibility. Regarding viability, or if you are making certain projections, so sometimes what happens, you give a deferred payment, and people say that I am going to earn out of the corporate debtor, and then I am going to pay certain debt through that recurring income. But now it's a subjective. Anyone will say your projections are too aggressive. So show a map that even if this doesn't work, my other set of business are there, which are running from so many number of years, then they do have a free cash flow. If I fail over here, then they would be able to match the flow which I am proposing. So have a good clarity over feasibility and viability. Then the plan should have provisions for its effective implementation. So whenever you are saying that you are going to ask this waiver or that waiver, show that how you are going to implement and how you are going to approach which authority, within what period you would be approaching, and how you are effectively implementing your resolution plan. Then plan should have a provision for approval required and timeline for the same. So always take a higher timeline. Under the scheme of IBC framework, 12 months are available. So always take an advantage and have a 12 months time period to take all approvals required to implement the plan. And E, the resolution applicant has the capability to implement the plan. So as I said, in capability, you have to show that you are having a background of similar line of a business. If you don't have a consortium, give certain stake to someone who is having experience of particular line of business, and then demonstrate your capability to implement the resolution plan. So in one of the matter, I'll just want to highlight what had happened in that matter. So they made a consortium. However, the consortium member was a real estate entity. So now acquisition of the corporate debtor is basically to revive the business and to restart the business. But since that consortium had a company which is having an object clause of development of real estate project, that plan was rejected. So whenever you make a consortium, have a proper analysis at whom you are taking on board. So have someone on board who is having a similar line of business, and don't take someone on board because of whose any other line of business your plan gets impacted. Then this is regarding approval of the plan. So as I said, RP is going to deal with the committee of creditors, and they would be inviting you for the discussion and negotiations, right? So ultimately, try to have all clauses factored in your plan so that it would be easy for the RP to demonstrate it before the committee of creditors. And as I said, section 53. So whenever you are proposing a distribution under resolution plan, read word by word section 53. See, whenever we have cleared IBC examination, so all of know section 53 clearly, and we know what should be the waterfall mechanism. However, when you are dealing with a resolution plan, always read it again word by word, because as I said, for 1.30 lakh rupees, someone's plan got rejected. If he would have provided that amount outside resolution plan, then his plan would have gone through. But since he provided that payment within the resolution plan, it got rejected because it was bypassing section 53 waterfall. Another another modus operandi that nowadays people are following is that they are providing for a blanket payment. So if I am offering 100 rupees payment to secured creditors, then I'll say I am making a payment of rupees 100 to class of creditor. Internal distribution can be decided by the committee of creditors, right? So that why that it is important, because sometimes you may not be aware regarding the security interest. There would be 3 secured creditors. However, one secured creditor is having first and exclusive charge over the factory land, and another secured lender might be having charge over plant and machinery, which is deteriorated, right? So you can't say that you are going to pay all the creditors in equal payment. So now, why to unplease someone? So always give a total payment to a specific class of creditor and leave it to the committee of creditor to decide how to distribute, right? So this will ease out a lot of pain as a resolution applicant. And if something goes wrong, you can always go to the NCLT and you can say, we had provided for the class payment to a class of creditors. If due to internal distribution there is an issue, then it's not my fault. So they will give you an opportunity to change your plan dynamics. So always give payment to class of creditor and don't distribute by yourself. Now, resolution plan document. So I have prepared an index that any resolution plan should at least have these clauses. So under these clauses, you should try to cover whatever best information is available, whatever facts which are available, and try to demonstrate it subjectively and objectively. So it should go like, have a preliminary background, then put interpretations. Because sometimes what happens, you are trying to say something, but they will interpret it other way. So always put interpretation clauses that these are your interpretations. Have a definitions. Whenever you are using abbreviations, always have a table of abbreviations. Then put disclaimers that you are relying upon the information provided by resolution professional, so that if anything goes wrong, if any information which is not synchronized with the information memorandum document, then you will have a right to debate it before the adjudicating authority. Give a background of the resolution applicant. Very important. Give a background of the corporate debtor, company profile, its shareholding pattern, date profile of the corporate debtor, who are the financial creditors, workers, employees, amount due to central government, operational creditors, any other liability. So all this information would be available in the information memorandum. So try to cover everything, try to address everything. As I said, information memorandum and RFRP, these are very critical documents and important documents. Spend good amount of time understanding it. Any queries with respect to RFRP and IM, straight away raise it to RP, so that subsequently, if anything goes against you, you can always produce it to the court. Then, point number 4, analyzing the viability and feasibility of the resolution plan, including addressing cause of default. So as we discussed a couple of slides back, addressing cause of default is very important, and demonstrating feasibility and viability is of equally much of importance. Then have a measure to successfully implement the proposed plan. So as I said, show a proper liquid flow statement and always have a backup plan. So if you are saying that you are going to fund this plan through this line of funds, and always have a backup plan. If I fail over here, I do have a sufficient flow to match the differential flows. If I am unable to match the flow over here, I will be able to match the flow through another stream of things. Then point number 6, key proposition in the resolution plan. So have a proper proposition that how you are going to deal with the default, what kind of model you are bringing in. So earlier, the same entity, same unit with same set of machinery, a rather better set of machinery, because it has deteriorated over the period of time. How you are going to generate a positive margin. So demonstrate your key proposition of the resolution plan. Show the management of the company. Have a profile of the people who are having expertise, or having a industry knowledge, or having a finance background. To put a profile of the people who are going to manage the new company. Then Always review interest of all the stakeholders. Have a proper statement in your resolution plan that how you are dealing with the interest of all the stakeholders. Show the history about implementation of any plan. So see, the code says the resolution applicant should not have a history of any failed implementation, but positively you should demonstrate that if you have any history of any merger acquisition, any revival, any rehabilitation, then demonstrate that history in the resolution plan. Then always have a clause in your resolution plan which says mandatory content of the plan. So what happens when you submit your plan? Resolution professional and a committee of creditor conduct the due diligence over the resolution plan. They do engage services of a law firm. They'll use services from AI companies which fetches the data from across the platform and all. So in before slide, I mentioned that you should do your own due diligence and you produce in the resolution plan itself, right? So have a table in your plan which shows these are the mandatory content of the plan and where you have addressed those. So it will actually cross checking of your own resolution plan. So if you cross check, you won't be able to miss any of the clause. I'll come to that point as well. Compliance form H. So compliance form H comes into picture when plan is approved by the committee of creditor and when the application goes to the NCLT, RP is supposed to sign a compliance form H. So you take the reference of the compliance form H and prepare your resolution plan according to the compliances which RP is supposed to verify and supposed to vouch for it. So always take a base of compliance form H, have a table and show where you have complied with these provisions in your plan. Then you should demonstrate the conduct of business after approval of the resolution plan by committee of the creditor. So show step-by-step process. Once the plan is approved by the committee, it will go to the adjudicating authority. Okay, so the authority will take certain time. How much of time? I don't want to comment because it may be a 2 month, 3 month, or it may take a larger period of time, because if there are any objections to your plan approval application, then it will take a lot of time. So have a proper clause that during this period, RP should manage the business operation and what kind of supervision you want. Because if you are declared as a successful resolution applicant by the committee, you are giving a performance deposit, which would be a substantial amount, and you should try to exercise your rights. You should have a clause in the plan that RP should allow you to see. You won't be able to make any decisions, but at least RP should allow you to visit the factory. RP should allow you to have your own security team at the factory, because when you have bid for the plan, you have done your due diligence. But if during the period of time it gets deteriorated, then the value once you are giving any plan, then it is locked and you can't change. So get a specific not direction, but take a liberty, request a RP that he should allow you to oversee the operation during the interim period. Then a step to be taken once approval of is given by the authority. Yeah, now, so once adjudicating authority approves the plan, maybe if you have given a payment in a single tranche in a upfront manner, like it is a within 45 days or something like that, then it's a different story. But if you are provided a payment within a period of year, 2 year, 3 year, 4 year, then there would be a monitoring committee, right? So you have to show that after approval, how you are going to get the control of the corporate debtor, what all documents corporate debtor or a committee of creditor or RP should hand over to you, how your name is going to be removed from the records of the CBIL, because once you acquire the company, if your name is not removed from the credit repository database, then for you it would be difficult to get finance from the bankers, right? So always have a prayer, request a committee through resolution plan that once your plan is approved, then your name should be removed from the list of defaulters, willful defaulters, or any credit repositories. So a step should be properly demonstrated that how you are going to approach Ministry of Corporate Affairs, how your name would be replaced by the X management, because to have your name in place of X management is also a task. So you have to be behind the ROC to get it implemented, because though NCLT is the adjudicating authority for ROC, but it is difficult to implement the order and the ROC. So have a proper step-by-step procedure, specific, see, I said specific waivers. So if that company is not compliant, if ex-management has not made corporate compliances, then there would be a penalty that has been accrued. So always try to get a specific waiver, get the penalty calculated from a professional company secretary, and then try to get the waiver of those in quantified terms. So if in order it is mentioned, then it would be very easy to implement that plan. Otherwise, what would happen? They will ask for the penalty. Again, you need to move an IA before NCLT. It will take a couple of months, and then ultimately you will get the waiver. You will get the waiver, but it will take time. It will take its own sweet time, I would say. Then you have to provide for the performance guarantee security. So if you are giving a deferred plan of payment, and if performance guarantee is a substantial amount and you are putting a deposit, and try to nullify it at the last tranche. So don't keep a plan wherein you have to make a payment and you have to get the refund. Always try to offset it at the last tranche payment. Then 15, 16, very important point, and it requires.
Sir, can I ask one question, sir?
Absolutely, sir, please.
Sir, my doubt is, you told that once the company under resolution and resolution plan is approved, we have to remove the defaulters list, that company to be removed from the defaulters list. I agree.
Yes, yes.
But the problem here is, as a banker, suppose we are taking action through personal guarantors also. Suppose we are removing the name from the defaulters list, how we will recover the money from the personal guarantors?
See, personal guarantee agreement is, see, you in personal guarantee agreement, basically that person is provided guarantee for the corporate debt. Right now, it's a settled law. Whenever there is a resolution plan, there is you are basically resolving a corporate debtor, okay, and you are not removing everyone from their obligation. So, as a bank, as a financial lender, if my claim was 100 rupees, and if I am getting, say, 30 rupees from the resolution plan, then 70 rupees right is still there. I am not extinguishing claim on my books of account.
So whether I can remove the name of the company?
Absolutely, sir. See, think from the angle of a resolution applicant. If I am a successful resolution applicant, I am acquiring a company, and still if my name is there in the defaulters list, if I am doing a merger and acquisition through resolution plan, so if I am giving a scheme of merger and acquisition, then ultimately my holding company will suffer because of that issue.
I totally agree. But the problem is that, suppose I am sanctioning a loan to a corporate debtor, and B and C are the guarantors.
Yes.
And for A, one resolution plan is already approved. But in bank book of accounts, the name of the borrower is still A. Then how come I can remove A? That is the question.
Yeah. Practically, I am with you. That would be a difficulty, and bankers are very hesitant to remove the name. But see, from a resolution applicant's angle, if they don't remove the name, then it would be a difficult task for you to get finance from any bank.
So what is the solution, sir?
Solution is always read the guarantee agreement. In guarantee, see, in guarantee agreement also we are providing for the amount that this guarantee is for, say for 100 rupees, 200 rupees, 300 rupees.
I agree, sir.
Yeah. So refer to the guarantee agreement and explain the bankers that, see, we have to explain the bankers that you are not waiving your right. Ultimately, you are approving our resolution plan, and you are just providing for whatever amount we are paying, and it is, see, there would be a haircut, but their claim still remains. They can always recover the differential amount from the parenters. So we need to explain them. I know it's a difficult task, but without getting this waiver, a successful resolution applicant will suffer a lot.
So, because if he was here, that is, I am a banker. That is the reason I am asking you.
I got it, sir. You must be banker because banker always remain a banker. You will think from the banker's angle, and that is true. So banker being a resolution professional is a perfect combination, because you will be able to give solution to all their queries. But I completely agree with you. It is a gray area, and you have to convince them to release your name from the list of defaulters.
Okay. Thank you, sir. Thank you.
So then,
sir, 1 minute, sir. As a ex-banker, I want to say something on this, sir.
Sure, sir. Sure.
Sir, we should not remove from the defaulters list, sir. What I suggest is, we can some other under watch or a resolution process on, like that. Otherwise, nobody knows. We should not penalize anybody. At the point of time, the real position should know to all the people. Removing is a bad precedent, sir. We should not remove. They should
sir,
be under watch.
Definitely, sir. As see, insolvency bankruptcy code itself is a 6-7 year old, right? And we are talking about the credit market which is there in India since independence, right? So this is a process. We don't remove the name, but if you don't remove, then ultimately purpose of the code won't
Sir, it is a
be
vicious
addressed.
circle, sir.
So
It is a vicious circle.
yeah, vicious circle. So that is the reason we have to come up with some solution and some system should be there
we
in
have
place.
to identify, because once we let the loose things, you know very well our corporates and bankers both are responsible for the NPA.
Sir,
I have my own experience in handling recovery.
Yes, sir. Yes.
I was an authorized officer under surface for more than 10 years. I know recovery is very difficult job.
Absolutely, sir. It is the most difficult and most important job to do. I have dealt with number of public sector banks, and in some bank it's a policy to transfer people who are not performer. They transfer people who are not performer into stress asset. Actually, you need performers in the stress asset recovery department, because that is the most important task to do.
There should be some check. Otherwise, with the IBC, it is a resolution plan will be a temporary unless it is successfully implemented. Some bankers, they don't have expert knowledge in monitoring. That also will cost.
Yes, sir. I'll give you the practical difficulty and a solution to it. We have that information utility, right? NESL. So banker gives, so head office or some regional office level people give the data to the IU with respect to the default and all. So a practical situation which I have dealt with, after successful resolution of the plan, after 7-8 months, through some central repository, the data must have gone into NESL. So that notice regarding default was received by the successful resolution applicant that your company has made a default, and you reply within 15 days of time, like that, right? So actually, if that IU is properly functional, then in IU you should have an option that this company has been resolved under IBC. Then there should be a specific mapping that these are the claims, this much amount you have recovered, and this much of amount is pending from the erstwhile management or the guarantors of the company.
Sir, my suggestion is, if the company is winding up, we are putting a head that under winding up, like that, under resolution, like that, some thing has to be known to everybody, sir. We need not punish.
Under resolution, that is for implementation period, sir. But once your plan is implemented, you are making a full
then
payment.
After it is successfully implemented, there is nothing wrong removing.
No, sir. But see, successful. What is implementation? If I am giving a resolution plan with a payment timeline of 1 year, if after 1 year I am making a payment, still there a recovery would be pending. No, there would be a cases under section 95, 96 running against the personal guarantor. There would be a recovery under Surface Act running against the personal guarantor.
Then put the personal guarantor under default.
So in IU, they should be mentioned as the erstwhile promoter of the so-and-so company or the guarantor of the company, and recovery is pending from these people. Yes, so some evolution. So if bankers like you take some initiatives and they educate the system, then it would be a great achievement.
Okay, sir. Thank you.
Thank you, Selvarajji. And after entire resolution plan, if you are asking for any special relief or concession, which you are not otherwise going to get, like a waiver of personal guarantee or release of certain assets during the implementation phase, sell certain assets and recover from those assets and pay the payment. So some exotic relief if you want, then always try to get it. So in our Gujarati, there is a saying that "Mangya vagar to maa bhi na peerse." If you can't ask, even mother is not going to serve you, right? So try to have a separate relief, but put it outside the resolution plan. So demonstrate that this is a separate relief, and for this separate relief, I am making an additional payment. So it's like if I am asking for waiver of personal guarantee, then provide for a separate payment and say COC can decline it. My plan is for the corporate debtor, but this is over and above the resolution plan amount that I'm offering. So if you are not interested, then fine, you don't give this waiver, but please consider my plan as a whole without that specific waiver. So try to always try to get whatever relief you want, but put it that way that people, COC or the RI, resolution professional should not reject your plan upfront. So I think this was a summary on how your resolution plan should be structured. Moving to next item, that is resolution plan to address. So your plan should address scheme of merger and acquisition under Companies Act. Very important, because if you acquire without getting approval on your scheme of merger and acquisition, then after acquisition you need to move in another application for merger and acquisition. But within IBC acquisition, through under IBC, you have a liberty to plug the scheme within the framework of resolution plan. So always have a scheme of merger acquisition. So when you are a company, so that even individual can bid for the company, even a partnership firm can bid for the company. But if you are a corporate and if you want to acquire that entity and you have to merge that entity with your existing unit or reverse merger, anything, always have a scheme of merger acquisition within your resolution plan. Always ask for specific approvals with the central government and state government. So as I said, do a proper due diligence, and whatever compliance lapses you have observed, ask for the specific waivers with respect to those non-compliances. Have a proper tax planning scheme. So I'm sure that many chartered accountants would be there as a participant who are into tax practice. So there are quite a few sections that you need to address. So what happens if company is having default of say 100 crore? So the company would be having liability of 100 crore. If I am acquiring that company for 25 crore, then I am actually waiving off that 75 crore. So if income tax department considered that 75 crore as income, then my entire carry forward set of loss would be utilized. I might have valued my loss and I might have make certain payments toward acquiring that loss. But if income tax department considered it as a notional income and it nullifies my loss, then I would be at loss. So always have a proper tax planning scheme into your resolution plan. As I said, engage the services of a professional company secretary, understand what or non-compliances are there in the corporate data as on CRP date, address all those compliances, and ask for the waiver for all the compliances with the adjudicating authorities. Also mention a proper accounting treatment as on the effective date. So what is effective date? Effective date is a date when NCLT approves your resolution plan. So always give a balance sheet as on effective date so that it would be easy for you to build your books of account from that date. So always have a proper projected balance sheet and accounting treatment with respect to your scheme of acquisition. And I believe this decision is known to everyone, Ghanshyam Mishra versus Edelweiss. So in that Supreme Court has made so many observations with respect to what kind of waiver those are permissible in a resolution plan. So always refer to this decision and try to plug your waivers synchronized with the waivers which were given in Ghanshyam Das Mishra case. Further, balance sheet as on effective date and projections for the period of plan implementation. Always have a proper projection with respect to your plan implementation in your resolution plan. Then comes section 29A due diligence. Now section 29A DD is a task of a resolution applicant. But if you demonstrate, for example, he will check whether you are in a willful defaulter list or not. But why not to provide a supporting document with respect to that your name is not appearing in the defaulter list? He will check whether your company is into CRP or not. You give a IBBI, on IBBI website, you have a search option. You show a print screen that you have already made this search and provide it to the RP that you are not amongst a company which is into CIR. You have access to a defaulter list of the CBIL. So see, try to give best analysis from your end, itself, so that there would be an easier part from the part of the resolution professional or COC. So even you have some companies like Signal X and other entities are like that based on your PAN, based on your CIN, they run a deep search over the open networks and they give whether any litigations are there against your company or mapped against your PAN. So it will cost you some 10,000, 15,000 rupees, but that report would help RP in making a informed decision making. Resolution plan vetting. So RP is going to do a plan vetting clause by clause. So why not to give a table in your plan itself that where you have complied with all these clauses. Compliance form H certificate. So ultimately compliance form H is the form which adjudicating authority is going to verify. So always take a reference while preparing a plan to compliance form H. See, when you are bidding, always bid like it. You have to become a successful resolution applicant. So always think about the final result and accordingly prepare your strategy. This is the summary of compliance form H, which says compliance to section 25(2)H, that is eligibility criteria, section 29A, section 30, A, B, C, D, E. So this is a best document to refer to while preparing a resolution plan. I think that's it from my side. And before concluding the session, I would say, if you see Code of Civil Procedure, it was of 1908. Companies Act 1956, Income Tax 1961, Code of Civil Procedure, Criminal Procedure 1973. So these all have grown over the period of time and still litigations are there. So Insolvency Bankruptcy Code is 2016. So it is actually in one discussion I said it's a bright kid which is undergoing its schooling. So because even government of India is also very particular and it is closing all development with respect to IBC. So I believe over the period of time, this code would actually create a lot of difference with respect to the Indian economy and Indian business environment. I'm keeping now meeting open for any queries, questions, suggestions, feedback.
Members may ask any question. I think everyone is very good clarity.
Either they have a good clarity or I was confused with respect to my talk.
No, you have explained very well everything.
I was told that I am having an hour's time, so probably I tried to wrap up things within an hour. So we can discuss anything. So I basically during initial slide I told that there are different perspectives with respect to resolution plan. So from RP's angle, from COC's angle, from NCLT's angle, from successful RS angle. So probably in last 3 to 4 years, I have represented all the angles, right? So even I have presented before NCLT from the side of a successful resolution applicant as well as from the side of a resolution applicant, right? Even I have contested a plan which was approved and our plan was rejected. So probably I have seen a lot of different environment and different situations. So if anything to discuss, I can definitely share whatever little experience I do have.
Yeah, Santoshji, you were asking some question?
No, I was not asking. I was saying Mr. Jigarji, he has explained very clearly. But yes, questions on account of patience we don't have since practical exposure is lacking. So on that grounds, no questions. Otherwise, the concepts he has explained very clearly. Thank you so much.
So my suggestion to everyone would be that always try to attend NCLT twice a week. That will give a lot of clarity. So when I started, I was very categorically and I deliberately went to the NCLT because it gives a lot of perspective, how people are arguing, what questions are being raised, and you read the orders. That will give, see, if you don't have any assignment, you won't get any practical exposure. But you go to NCLT, then it is as good as getting a practical exposure because all are live matters which are getting contested litigation. So it will give you a lot of practical knowledge. And now since last 2 years NCLT is online, so even you don't need to travel to NCLT. You can log in, you can have a good listening to what matters are running, and then make a note, refer to the provisions, and actually that will give you a lot of good practical knowledge.
One question. Hello.
Yes, sir. Please.
You have told that legal due diligence of CD has to be done.
Yes, sir.
Practically what we do, we ask CD by writing if any litigation is there or not. So if he says no litigation is there, we accept. Even
No,
after
sir.
that, legal due diligence is required.
Sir, what happens? As information memorandum, earlier we were getting 54 days. Now I think we are having 110 days to prepare an information memorandum as a resolution application. So within 54 days, you have a claim verification period. Now claim verification itself is a task. So RP would be highly occupied for initial 40 days. And another challenge is to get the approval from COC to get reappointed as an RP, right? Because in most of the cases, there would be a replacement. So RP would be more focused on the work and he won't be very much into preparation of information memorandum. So when information memorandum is prepared and it is available for the resolution applicant, it will have, I'll say it will have 95% information. But if something is missing, if you are not asking for a specific waiver and if you become successful resolution applicant, then it would be your pain. Basically, you are buying their liabilities. If you conduct your own due diligence and if something is not provided in information memorandum, but you are additionally mentioning in the resolution plan, then it would be helpful to you and it will save you a lot of time, energy, effort subsequently. Because
So
after
means
becoming
PRA has to do legal due diligence, not RP.
PRA must do. Yes, PRA must do. So
it is not the responsibility of RP, na? It is not the responsibility of RP.
It is technically, sir, it is the responsibility of RP to prepare an information memorandum which should cover everything, right? So subsequently, if you become successful resolution applicant and subsequently you realize that something was not properly provided for in information memorandum, then it would be a litigation. You will say you have. So I have witnessed one matter where approach road was not available. So you can't access to the factory premises of the corporate debtor because that approach road was not available officially. Based on that, a 25 crore or 30 crore rupees resolution plan was ultimately rejected. It was approved, but however, then PRA said it was not informed to me that that approach road is not available. So now to get the approach road, I need to pay certain amount to the adjacent factory owner to give you access to the premises. So now that was not factored. So you should do ultimately buyer be aware, right? You are buying something, then you should do adequate due diligence before giving your bid.
So means if RP is not doing legal due diligence, it is not that much troublesome for RP, correct?
It would be, sir. See, this entire talk is with respect to resolution applicant side, right? So if we are on the side of resolution applicant, then we should do our due diligence. If I am an RP, so I will definitely try to do my due diligence because ultimately I would be responsible. No? Tomorrow, if any plan or any litigation goes into NCLT and if any adverse order is passed against me, then definitely IBBI is going to take action against me. Nowadays, if you see the disciplinary orders, if any order is coming against you, immediately IBBI triggers the inspection on your assignment. So as an RP, so you have a lot of responsibility. But once you are successful and if you have the control over the corporate debtor, but if you have to approach to several authorities to get the plan implemented. So if nothing is mentioned in the order with respect to that waiver, then it would be difficult for you to implement the plan.
Okay. So one general question.
Yes.
Okay. In IBBI is doing inspection in all the cases or wherever some issue is there or some complaint is there?
Sir, IBBI is having a specific policy that over the period of 3 to 5 years, they want to cover all the RPs who has handled more than one assignment.
Okay.
So what happens if you are having some 5, 6, 7 assignment, then they will trigger an inspection over a couple of assignments. But if any complaint against you, then they will trigger. If any NCLT order against you, then they will trigger. So as per their policy, over 5 to 6 years, they are going to cover everyone.
Okay.
And now they have also introduced a peer review. So in CA and even CS, there is a peer review framework. Now they are introducing this peer review framework in IBBI insolvency profession as well.
Okay. Thank you.
Good evening, sir. It is something not specific to the resolution applicant.
Yes, sir.
Yeah, this is regarding a small confusion still exists regarding the regulation 32 of liquidation regulations.
Hmm.
This is something like standalone, slump sale, collectively, assets in parcel, and later CD as a going concern and business concern. What will be what is the difference between assets and parcels or standalone or collectively?
Sir, they have tried to cover all possible situation. However, it would be case specific. If you are having a corporate debtor which is having 4 factory sheds, if these factory sheds are adjacent to one and another, then it would be a different thing. But if these are scattered sheds, then you can sell it as separate sheds differently, another shed differently, like that. So see, within that 32, they try to cover whatever permutation combination that would be available. So they must have certain thought process. There must be a committee before deciding this. So it depends upon the nature of the corporate debtor. So it has to be read in reference to the underlying corporate debtor. So
can it still be called as a successful resolution?
Sir, it would be a liquidation. Ultimately, yeah, it would be a liquidation. But even in a liquidation as a going concern, that concept is there. But what happens in resolution plan during CIRP, you have a right to acquire corporate debtor as a going concern, right? But in liquidation, you can always pray for acquiring a corporate debtor as a going concern, but it is up to adjudicating authority to allow you or not. In CIRP, as a successful resolution applicant, we have a right to acquire as a going concern, but now we are at the mercy of the authorities. So it depends upon case to case and how strong you represent your matter.
Yeah, hi Jigar sir, this is Vinod. How are you?
I am good, Vinodji.
For the information of our members, I am having a specific question. See, suppose there are 15 resolution applicants.
How many?
Are you getting me? 15, 1-5.
Great, sir. Okay.
No, I'm taking a very good.
Yeah, but this is quite
15 resolution applicants.
Yeah.
Now everybody is interested to buy this property. They may be given different pricing. What are the? Is there any hope for them to get betterment their resolution values, or the bank is giving, or the COC is giving opportunities for them to better the value negotiations and all those things?
Right, sir. So what happens? You have to refer to the RFRP document. Usually in RFRP document, people do have clause that they would be inviting, say, top 3 or top 5 resolution applicants for negotiations. Sometimes they do have clause that they would be inviting everyone. So if you see the section in which you are supposed to invite, as a resolution professional, you are supposed to invite the resolution applicant when you discuss his plan in the meeting, right? So definitely they will invite you. There would be negotiations. Now, in an amended regulation, they will introduce a challenge mechanism. So you can negotiate over resolution plan using a challenge mechanism. Now, challenge mechanism is not defined. So challenge mechanism could be an inter-se bidding. So in one of our matter, we did an inter-se bidding. There were 6 resolution applicants. So we, in first round of negotiation, we arrived at the best offer of, say, 100 rupees. Then we set up an auction kind of a platform for CIRP. So in which we gave a base amount, the amount which was the best amount for first level negotiation. Then we gave a time window to them for bidding. And there was a specific 50 lakh rupees bid we allowed, that you have to increase your bid with rupees 50 lakh, and a 1 hour window was given. So it was a challenge mechanism used. And if you are the highest bidder, then we'll give company to you. So kind of system we had used.
Correct, but there is no regulation come as of how the challenge mechanism is executed.
So ultimately, yeah. So if you see the regulation, if there are more than 2 resolution plans which are put up for voting, then there is a formula which is to be decided prior to finalizing a RFRP document. So in RFRP, you will have a clause. So tiebreaker formula would be there. So in RFRP, that would be a clause with respect to with whom you are going to negotiate. Usually as a COC, and even the people who are having a banking exposure, they'll know why to restrict ourselves. If there are 7 people, then invite all 7 for negotiation. Yes. Why to restrict ourselves?
My connected question.
Yes, sir.
Since the challenge opportunity is there, and one or two resolution applicant is not invited for a negotiation, it can lead to a litigation. My lord, I am not given an opportunity for that.
Yeah, definitely. But if your RFRP document says that you are going to invite only top 3 bidders, so top 3 PRs you are going to invite, then your RFRP was a document which was shared to all PRs, right?
But again, sir, the top 3 is an arbitrary number, not as per IBC code. Correct, no?
Sir, why? See, now top 3, you have an evaluation matrix as well. Top 3 means the people who have scored highest over evaluation matrix. Now,
Correct,
evaluation matrix is an exhaustive document which is having a objective as well as subjective criteria.
Correct,
so
I do agree.
You have to follow the evaluation matrix and try to get the maximum score in the evaluation matrix.
Correct, sir. So, like that, if they are restricting to 3 people,
yes,
then the opportunity for the others are restricted by COC.
Yes, absolutely. But CIRP is a time-bound process. I can't have a multiple round of negotiation, no?
No, my contention is that I should give at least one opportunity to negotiate.
Very true, sir. Practically, I agree. Absolutely agree with you. You should invite everyone once.
Therefore, if in a case, RFRP say only 3 are the highest 3 are the only people going to negotiate, then my opportunity is restricted. It can lead to a litigation further.
So litigation won't be there if your RFRP document says that they are going to invite only 3 people, right? There won't be any litigation because see, you will file an IA. Ultimately, it would be heard and it would be disposed on the day 1 itself. Because if RFRP document is clear, because it's ultimately commercial wisdom. Now, commercial wisdom
correct,
of the COC is of supreme.
Correct, sir. But commercial wisdom, supreme, everything I accepted. But money maximization of value is the preamble. On that ground, I can approach adjudicating as my lord. I could have given for this much if I could call for a negotiation.
No, but then while bidding, you should give your best offer, no? Why you are trying?
No, sir. The thing is, my dear sir, we don't know what is the best option is going to come.
That is the reason. That is the reason I said you should engage a registered valuer while you
my dear sir, diligence. Yeah, I got it.
So ultimately, you should try to give the best bid at first go itself.
I just challenge it like this. Okay, I have involved I have deployed IBP valuer, and he given the value. Based on that, I am bidding. Now see, the challenges are taken on the ground that RP will say, "Na value arrived at based on the valuation given by the IBP valuer." I am also going to take the challenge with the valuer. See, you know why I am taking this matter in different manner. See, there are people who want to regain the property in one way or other way. Correct, na? We don't know what is the value. There is, unlike in liquidation, there is a guideline value is there. For a resolution, there is no guideline value. The value is based upon the valuation given by the IBP valuer. My lord, I am also employed IBP valuer only. Based on that only, I have arrived at the figure. If I have deployed that party, he did the valuation for the RP, then I could have done at a better price. My lord, therefore, looking into the essence of the preamble, my application should be allowed and I should be given opportunity for improve my resolution. This way can turn around. Since there is provision given that improvement is possible.
True, sir. You are talking about something which should be there. And as a banker, I would say, if I am a committee of creditor, I would invite everyone because even as a committee, I want to try. No, why should I restrict myself to 3 people or 5 people?
Yes.
But if your RFRP document is very clear that you are going to invite only top 3, then in court of law, see, once your RFRP is there, which is circulated to everyone, then it's a very important document and it's a legal document.
Right, sir. Agreed.
But technically speaking, you should invite everyone, at least for one round of negotiation.
Yes. That's what I just taken it up for the knowledge purpose of our member.
Yeah, sir.
Also, let me also get an interaction with you to get raise.
Sure, sir. We will be in touch. Definitely.
Great, sir. Go ahead with your elaboration, sir. Please.
I am done with my talk. So if anything to discuss, we can discuss on anything on CIRP or liquidation.
this presentation you will be sharing to the team, so that they will also get benefited whatever it is there.
Yeah, sure. I will share. No issues.
So Puranik sir, can you please connect, or Panigrahi sir, please connect it and circulate in the group so that everybody will get it on. It's if you are through, then before I conclude, just tell you, sir, come with some other materials. I mean articles or any area of importance, so that it will be enrich our members, right? So please plan something in the future.
Definitely, sir. We'll definitely meet again.
Thank you.
So I hope we have learned something out of this talk. That then it's a success. Yes, Panigrahi sir. So Puranik ji, I am done with my talk. Anything to discuss, then we can keep it over.
Yeah, Panigrahi sir, anything you want to say? Quick 2 words about JIGAR sir. Panigrahi sir.
I think there is no question. We invite Vimalji to vote of thanks.
Jigar bhai, incidentally, I was there in Ahmedabad for 3 years. My office was in Navarangpura.
Okay.
I was in Corporation Bank.
Okay.
So good to see you from Ahmedabad. I am happy. I am thankful to you for giving such a nice interactive presentation. Really, each and every point you are very clear. Your concept is very clear. Really, I am happy. I am surprised to see each and everything you could explain very nicely. Thank you very much, and I will request you to give more presentations for the benefit of our members. Will definitely be benefited by your
Definitely, sir. Definitely. So even why I in the morning only I jotted down this presentation. So actually, see, IBC is a code where whenever you read, you will learn something new from that code.
Yes.
So even by preparing this small presentation, I okay, this is also provision.
That,
okay, I should take care
that
of this.
idea you have given, section 53 every time you should read.
Yeah.
So really, it is very. Thank you very much once again on behalf of PIPPL and all our members. Thank you very much.
Thank you, sir. Thank you. Thank you all members for patience.
Thank you, everyone.
Yeah. Thank you.